Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in to the October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. In April 2022, the court heard arguments in Siegel v. Fitzgerald, a bankruptcy case concerning fee increase exemptions in 2 states. Joining today to discuss the argument is Allyson Ho, partner in the Dallas Office of Gibson, Dunn, and Crutcher, and co-chair of the firm's nationwide Appellate and Constitutional Law practice group.
In this case, the court confronted the question whether a 2017 law that increases fees in some bankruptcy courts, but not others, violates a provision of the Constitution's bankruptcy clause that directs Congress to establish uniform laws on the subject of bankruptcies throughout the United States. I previewed this argument in the Federalist Society's A Seat at the Sitting, which is available to listen to for more background on the case. I plan to dive straight into the argument on this podcast. As a reminder, in this kind of case, the remedy for any violation can be one that levels up, which would involve refunds to those who overpaid, or one that levels down, which would involve going after those who underpaid. Or, as several justices put it, it's a question of refunds or clawbacks. By my count, at least 7 justices asked questions about what the remedy should be if the court agrees with the petitioner that the 2017 fee increase violated the Constitution. In fact, the court not only peppered counsel with questions about the appropriate remedy, it also did so for about 10 minutes past the time allotted for petitioner's opening remarks and about 5 minutes past the time allotted for the government, too. Justices Alito and Gorsuch focused almost singularly on the remedy issue, with Justice Gorsuch telling the attorney for the government that he was going to keep repeating his question until the government attorney answered it. Justices Sotomayor, Kagan, and Kavanaugh also closely questioned the parties about what relief should be afforded if they ruled for the petitioner, with many questions centering on what Congress would want and how to interpret the history of the interactions between the Judicial Conference and Congress after the 2017 fee increase. Notably, the Chief suggested a path of avoidance, pointing out that the question presented didn't encompass the remedy question, meaning that the court could answer the merits question without ruling on the appropriate remedy. And the Chief has often remarked that if it is not necessary to decide something, then it is necessary not to decide it. Justice Barrett similarly asked whether the court could take a less assertive approach and let either the lower courts or the Judicial Conference figure out the remedy in the first instance. While the justices may have been just testing the boundaries of the arguments, that 7 justices drilled into the remedy is suggestive that there's an appetite to hold the 2017 fee increase unconstitutional. If so, it remains to be seen whether the petitioner will avoid the "I brought a successful constitutional challenge and all I got was this lousy t-shirt" result I described on the previous podcast. On that note, and on the merits, Justice Thomas was particularly interested in the question of what the phrase "on the subject of bankruptcy" means in the Constitution. The government offered a substantive procedural distinction. Rules that focused on the relations between the debtor and creditors, the government argued, are substantive and subject to the bankruptcy provision. According to the government, the administrative fee structure here is merely a rule of procedure that doesn't affect the debtor-creditor relationship and so isn't subject to the provision. The justices seem skeptical that these bankruptcy fees are merely procedural and not on the subject of bankruptcy. Justice Thomas, for example, pushed back by pointing out that the fees diminish the amount of money available for distribution to creditors. And although the government responded that other laws not on the subject of bankruptcy, like tax and ERISA laws, also affect the pot of money available to creditors, Justice Barrett noted that these laws aren't plausible exercises of the bankruptcy power. Justice Kagan also seemed unpersuaded by the government's contention, observing that this is a top-down imposition of a fee structure that predictably can't help but disadvantage both debtors and creditors in 48 states, and that's by virtue of a congressional decision that's directly related to bankruptcy. Now, the petitioner didn't get off easy on the merits either. Out of the gate, Justice Thomas asked counsel for petitioner to pinpoint the constitutional deficiency. The initial decision by Congress to treat Alabama and North Carolina differently from the other 48 states, or the later decision by Congress to increase the fees for the other 48 states without mandating that the Judicial Conference increase the fees for Alabama and North Carolina too. Petitioner's counsel responded that both decisions had constitutional ramifications, and Justices Thomas and Kagan suggested that the fee increase may not be problematic unless the original division between the states was too. Several justices, like Justice Breyer, also posed hypotheticals to test the boundaries of the petitioner's uniformity argument. While Justice Sotomayor said she had a gut feeling the government couldn't increase fees for only 48 states, she also said she didn't want to write a decision that always mandated uniformity at the expense of allowing Congress to experiment. So, while various justices debated the reasons why the fee increase might be unconstitutional and what the remedy should be if so, I'll just leave you with this quote from the Chief to signal where the case may be headed. "What might make this case different," the Chief observed, "is that you're dealing with cold, hard cash, and that is a big deal in bankruptcy."
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.